Do you really want the U.S. Supreme Court redrawing district lines every time individually based on party? If you're an advocacy group out there, man, oh man, you better have the cleanest case of all time. And you better have some unbelievably clear legal standard, because short of that, the U.S. Supreme Court's not going to get involved. Hello, everyone. My name is Kurt Mueller. I am your favorite patent attorney, and we're here with another decision of the United States Supreme Court that deals with political gerrymandering and how congressional districts are drawn. This is from the state of Wisconsin, Gill versus Whitford, and as you can see in the header, this is an appeal to the United States Supreme Court, not a writ of certiorari. That detail is going to become very important at the end, so we're going to discuss why that's going to matter so much going forward. But first, let's discuss a little bit about the background of this case and understand what the United States Supreme Court is trying to decide. This case deals with representation from each state to the United States House of Representatives. So right now, by U.S. law, there are 435 members of the U.S. House. That number is subject to change, but it hasn't been changed since the very early 20th century. And those seats are divided based on population. Every state automatically gets one, and the remaining districts are divided based on population. So very small population states like Alaska just get the one. So if you want to draw the one political district in Alaska, it's very easy. Just draw a map of the state and you're there. Other states are not so easy. California has the most with 53, and the state of Wisconsin has 8. So we need to divide the state of Wisconsin into 8 districts. Now, there are a couple rules for this. The rules are, first, that the districts have to be contiguous. That means they have to be one whole part. You can't have one geographic part and then separated another geographic part. You have to have them as one continuous whole. Now, you can link them via very thin lines indeed, and you can see examples of this in other maps, but they have to be contiguous. You have to draw, there has to be one solid area that defines a district. So that's the first thing. The other thing is that they have to be compact. What compact is a little bit harder to define and a little bit more nebulous, but it means that they can't be too sprawling. And obviously that's a little bit more subjective. It's easy to see if something is contiguous, not as easy to see if it's compact. And the third thing is that they have to be equal in population. So as near as practical, every district has to have even number of population. So if you're dividing your state 53 ways, you take the total number of population divided by 53, and that's what each district has to be, rounded off. Obviously we can't have fractional people, but as near as practical. So those are the major rules. And then due to the 13th, 14th, and 15th Amendment and the Voting Rights Act, you cannot discriminate on the basis of race. So you cannot take a race into account. Otherwise, the rules are pretty open. You can pretty much do anything and take a whole bunch of things into account on how you draw districts. Now, people will argue that some of these things are legitimate and some are not legitimate. One of the classic things that is normally thought of as legitimate by a lot of people in this domain is areas of interest or classic communities, if you like. So all else being equal, if you are drawing districts, and remember they have to be equal population, so you're always bound by that, but all else being equal, you might decide, if you had the choice, to put a city within a district rather than splitting the city down the middle. So if you could draw 2 different districts such that the districts split the city in middle, or the entire city was within one district, you might very well choose to put the entire city within one district, because that would represent a natural community. People congregate into the community, they congregate into the city. They're thought to have some common interests, and their voice would be diluted if their voice was split. So you might put the city wholly within a district. Same idea with a county, all else being equal. You might try to put the entire county within a district. So, and these are sort of natural considerations that you might put into play. So you might consider these communities based on a whole lot of things, like the employers that they work for, the cities, the counties, the school districts. There's a whole lot of factors that you might throw into the mix. And so this case deals with, can you consider politics as part of that? Can you purposefully design the district so that it favors Democrats or favors Republicans? And on here I have a graphic that shows how this might be done and shows the varying results. So this is a hypothetical district that we have created. It has exactly 50 people in it. And in this hypothetical state, I guess we say, in this hypothetical state of exactly 50 people, we want to create 5 districts. So each district has to have exactly 10 people in it. We know that's the rule, and we also know that they have to be contiguous. So they're laid out in this exact geographic pattern. All the red people are on the left-hand side, and all the blue people are on the left-hand side. This is somewhat unrealistic, obviously, but it's meant to demonstrate the point. So we have 60% of the people that are blue and 40% of the red. So we want to have 5 seats. So if we divide it based on map number 1, what they label as perfect representation, then we have 3 districts of blue and 2 districts of red. So that's a 60-40 split in the same direction as the population. So this would be a perfect representation. However, if the blue party is the one that's drawing the line, they can go with option number 2. These are compact and they are contiguous, but rather than 40% of the seats being red, 0% of the seats are red. We were able to pack the districts in such a way as to exclude all representation from the red party. And if the red party is the one that is in control and drawing the lines, you can see here that they can actually put themselves in the majority, even though the red party is only 40% of the population. With a little clever map manipulation, they can make sure that they actually get 60% of the seats, so they can punch above their weight, if you like. And this is obviously not a completely abstract thing. This is a thing that exists in the real world, where parties select based on the parties in control of drawing the map are the ones that determine this. And the maps are drawn or redrawn after the census. We do a census every 10 years on the 10-year mark. So the next census is 2020. And population changes. So some states will lose congressional seats and some states will gain congressional seats because they're divvied up based on population. So Wisconsin may gain a seat, they may lose a seat, they may stay the same. But every state that changes its number of seats in the U.S. House has to redraw its map. So the body that does this is the state legislature. And the state legislature is in control of a particular party. And that particular party may be inclined to draw the lines in such a way as to favor their party. This is the concern. And this has been argued as being a real problem. Now, this is not the first time the United States Supreme Court has dealt with this problem. There have been a couple other cases of note where they have dealt with this sort of political gerrymandering, but every single time that they've ever heard a political gerrymandering case before, they have pretty much dodged the question. They have said that they can't decide it. They say that there's no rule to apply. They say they can't figure out if a district is drawn politically or not. It is a little bit hard to come up with a test that says if we apply this test, we can determine this is politically motivated. It's a little bit hard to think of how you would prove that or disprove that. And so in the past cases there's usually not been a majority opinion at all. There have been like these four-person plurality opinions, which basically say, well, we think that this is a problem, but we don't know how to apply that. And so this case came about where the people from Wisconsin said, we come up with a test that will solve this problem. We have a way to solve this problem. What we're going to do is we have this wasted vote test. And it goes into detail in the opinion describing that. But basically what happens is you say, here's how many votes you needed to win. And here's how many votes you actually got. Every vote in excess of what you needed is considered a waste. And then based on some calculations where you compare the wasted vote percentage from the districts and compare them all together, you come up with a percentage split that compares how many wasted votes there are in one district versus another. And you can do some mathematical calculation and you come up with a percentage that says, well, this is basically the percentage likelihood that this state is politically gerrymandered. And they suggested a threshold of 5 to 7% as the number that you might apply to find this. So they put forward this mathematical model. They said this is a mathematical model you can do that if you follow this rule, it will be applied and we can determine if they're politically gerrymandered. And the Supreme Court, we'd like you to adopt this test. Well, the United States Supreme Court didn't adopt the test or any other test. They kicked this back to the lower court for some further decision. based on an issue of standing. Standing is a really important issue. I should note right here that this decision is 9-0. It's unanimous, okay? So a lot of people give the Supreme Court flack for being partisan or biased based on a political ideology. This isn't one of those situations. The court was unanimous, 9-0, that the parties did not have standing. So there was no disagreement on that point. Standing is a really important concept. It basically means that you have to show a personal, individualized injury. The courts don't like sort of a global injury. So if your objection is that you are harmed in a sort of global way, the courts won't recognize that. You have to point to some sort of individual injury that is affecting you personally. And the Supreme Court said that the plaintiffs here didn't do that. They didn't show the particularized injury. They made this sort of global claim that their vote was diluted. There was vote dilution. And now the Supreme Court basically says that may well be true. There's vote dilution, but that doesn't harm you in an individualized, recognized sense. What does that mean that your vote has been diluted? How is that affecting you? You didn't make the case. You didn't come forward on the theory. But the United States Supreme Court said that they had preserved the issue, even though they hadn't really successfully argued the issue. So they sent it back to the lower court to see if they could actually make the case, if they could actually make the individualized case that they've been individually harmed and have another chance at this. So, this case isn't over. They're going back to the lower court to show if they could have sufficient standing to show that they've been personally injured. And the 4 members of the court, in a concurring opinion, laid out a fairly extensive roadmap on exactly how to do that. A lot of the time, the Supreme Court, when they're saying, go do it over, they don't really tell you what to do. This isn't one of those situations. 4 members of the court laid out a fairly detailed roadmap of exactly how they think that you could go to put this together. So if you were trying to figure out what you should do, 4 members of the Supreme Court have told you in fairly extreme detail of exactly what to do. So the plaintiffs in this case aren't left trying to just figure it out. They've been left a extremely detailed roadmap of exactly how to make their case and prove their point. So you can be well assured that they're going to try to do that. Whether or not the facts of this particular situation allow for that is a whole other problem. Maybe they can't make that kind of case. But this roadmap, of course, is not just for this case. The roadmap is for any future case. So all the voter advocacy groups that are out there right now are going to be looking to this and seeing if we can find some people, maybe with some better facts in a better state, that we can better map to this specific thing and say what we want to do going forward. So whether or not these people will be able to prove standing in the end is unclear, but the roadmap is clear on how someone could, and it's not a mere hypothetical. It's definitely possible for someone to do it. So someone's going to try, and this is going to come back up to the U.S. Supreme Court in the future. Now, there is another problem other than just standing, and the problem is judiciability. Not every case is something that the courts can hear. Or not every case is something that the courts will agree to hear. There's something well understood called the political question doctrine, which basically says that if something is a purely political question rather than a legal question, the courts won't get involved. So an example of a political question might be, what should the highest marginal tax rate be? That's not a legal question. There's no legal answer to that question. It's a pure issue of policy. Congress is the one that sets policy. Now, their tax laws may be so complicated that, and they are incidentally, that the U.S. Supreme Court has to try to figure out what Congress wrote. But the fact that Congress can write it is Congress. If they said unambiguously the top marginal tax rate is 35% versus 50% versus 90%, those are all policy choices, and the Supreme Court's not going to second guess that. So that's something called the political question doctrine. The political question doctrine is an example of, but not the only reason that courts won't agree to hear the case. Another reason is if they cannot find a workable standard. Even if there's an injury that you have, if they can't find a standard to apply, if they can't find a rule to apply, it's considered non-judiciable. It's like, we know something bad happened, but we can't figure out a rule to determine what that is, and so we're just not equipped to do that. The courts, The courts to find standing also have to be able to find a remedy. So determining that you've been injured is one thing. Determining what to do about it is a whole nother problem. And if the courts cannot figure out what to do about it, it's considered non-justiciable. And that leads us to one of the reasons that this kind of case is so important, and why the plaintiffs have to be real careful in how they make their case going forward, because what the U.S. Supreme Court has generally tried to avoid is getting into politics. Now, you can probably think of any number of U.S. Supreme Court decisions where you think that they have gotten into politics, and perhaps they have. But the United States Supreme Court has made those as exceptions, and I think that it's a fair characterization to say that the U.S. Supreme Court wants to avoid politics to the maximum extent possible. And maybe they haven't always been super obedient to that rule, but they want to avoid political, because they're not inherently a political branch. They're a legal branch. Your political branches are legislature and the executive branch. The courts are not supposed to be a political branch. They're supposed to be a legal branch. There is the huge distinction. And if you are redrawing congressional lines, if you're redrawing where the seats of congressional districts are, it's really hard to imagine how you can do that without it being political. So the U.S. Supreme Court is very, very interested in finding a test that can be very cleanly applied by the district courts. And the reason that they're really interested in that is because of the first word after the case name, the word appeal. I told you we were going to come back to that. That word here is really, really important, because most cases come to the U.S. Supreme Court by what's called a writ of certiorari. You will not find those words anywhere in this case, because this case did not come from a writ of certiorari. This case came from an appeal. Congressional district lines and how they're drawn by congressional statute are, when they're tried at trial, they're tried by a 3-member court. So most times at trial, it's one judge, right? This is what you typically see. So that is the norm. But Congress decided that in congressional district and redistricting cases at the trial level, it's a 3-member court at the trial level. So this trial that occurred in this case, and there was a trial, was a 3-member court trial. And the U.S. Congress also decided another thing. They decided that if a case is tried by a 3-member district court as a trial, it is a right of appeal to the U.S. Supreme Court. The U.S. Supreme Court doesn't get to decide whether or not to hear this case. They are the Court of Appeals. Normally, you would appeal to one of the courts of appeal, the courts of appeal for the Ninth Circuit, courts of appeal for the Seventh Circuit. This is a time, it's one of the very few times when the U.S. Supreme Court is the Court of Appeal. You go straight from the district court to the U.S. Supreme Court on a right of appeal. And that's why that word appeal is really, really important in this decision. It's also really, really important as to why the U.S. Supreme Court wants to find a super clean standard. Because the very, very last thing the U.S. Supreme Court wants to do, the very last thing they want to do, is try to decide every one of these redistricting cases from the facts that are specific to the case and decide that at the U.S. Supreme Court. They do not want to redecide these cases one at a time on a fact-specific basis. Because if they decide a case from Wisconsin, fact-specific, and they decide a case from South Carolina, fact-specific, and they decide a case from Washington State, fact-specific, and suddenly they're giving all these different answers. And how is that going to look, regardless of what it is, how is that going to look as non-political? That's the real problem here. The U.S. Supreme Court doesn't want to do politics. Every time they've ever done politics in the past, when they arguably have, they've gotten burned. I mean, how much flack have we ever given them for every political decision they've arguably made? The U.S. Supreme Court, if they're going to start redrawing district lines for congressional districts based on party, I mean, how's that not political? That's the problem here. And that's why the U.S. Supreme Court, not only in this decision, but the decisions that led up to this, and there were 2 major ones of note that led up to this in the past, the U.S. Supreme Court has basically in the past found it non-justiciable. because they need, this is not one of those circumstances where they can be a little vague and leave it to the lower courts to figure it out and let the courts of appeal come up with different standards and different tests and ultimately resolve it someday. That isn't the situation, because they are the court of appeal. They need something super absolutely clean that everyone will accept as non-political, so the district courts can just do it and every appeal will essentially be moot. They can just simply say, your appeal is, they can do it on paper. They can simply say, and which the Supreme Court can do, incidentally. They don't have to have oral argument. They do a lot of decisions just on paper. So they could set this up, and they want to set this up so that when people appeal, on paper, they can just simply say, well, we heard your appeal, but it was completely based on our decision. The district court didn't screw up, and your appeal's basically denied. They can do it basically as a summary decision. They can do it in one paragraph. And that's what the U.S. Supreme Court wants to do. The U.S. Supreme Court does not want this to be piecemeal. They do not want to be one at a time. They do not want every case to be individually considered based on the facts. Because do you really want the U.S. Supreme Court redrawing district lines every time individually based on party? It's like, the U.S. Supreme Court doesn't want to do that. So that's the real problem. The standing issue is a legitimate issue. I don't want to push that aside. It is a legitimate issue. I agree with the court here. There wasn't standing. But the standing issue, while legitimate, is a convenient excuse for the U.S. Supreme Court to really avoid the issue. And the reason they want to avoid the issue is totally legitimate. They want to avoid the issue because they need desperately something super clean so this doesn't become political. They need something that the district courts can apply and everyone will accept. So maybe that's this wasted vote standard that they came up with. Maybe not, but that was the problem in the prior cases where they refused to overturn things based on party affiliation, where they refused to say this was a partisan improper thing. It wasn't based on the fact that they thought that was wrong. The U.S. Supreme Court seems to think that based on prior decisions, they seem to think that redrawing things based on party is wrong. They seem to think it's unconstitutional. It's just not clear that they think that they can do anything about it. It's not clear that it's judiciable. And this is, sometimes, and this may be one of those times, it may be the case that it's unconstitutional, but the U.S. Supreme Court ultimately won't be able to do anything about it. Because they just cannot get into the issue. So unless someone can come up with a truly judiciable, clean standard, and maybe it's this wasted vote standard and maybe not, but unless they can come up with something super clean as a legal standard, I don't think the U.S. Supreme Court's ultimately going to get involved. Because they can't. If they can't come up with something super clean, there's just no way on this earth that they want to hear every single one of these things as an appeal of right. They don't want to decide. Every time that of course, the U.S. Supreme Court's partisanship changes. New presidents are appointed. New senates are appointed. People leave. People retire. People die. New members of the court are appointed. Do you really want the U.S. Supreme Court every 10 years, every time there's a census, and half the states are redrawing their lines to hear and redraw based on political lines 25 states every 10 years? You want the U.S. Supreme Court doing that? As bad as it is for the state legislatures to do that, at least they are partisan. At least you can write them off as partisan hacks if you're so inclined. The U.S. Supreme Court does not want to go down that road. They really don't. So if you're wondering why they punted on this case, if you're trying to figure out why they didn't decide the issue, that's why they didn't decide the issue. That's exactly why they didn't decide the issue. They need it to be super unbelievably clean. And this was not super unbelievably clean. The word appeal here is the key word of the case. It should tell you exactly why the Supreme Court is super hesitant to do this. And so if you're going to try to do this, if you're an advocacy group out there, man, oh man, you better have the cleanest case of all time. And you better have some unbelievably clear legal standard, because short of that, the U.S. Supreme Court's not going to get involved. Normally, the Supreme Court doesn't require perfect. This is kind of one of those times they're going to require perfect. That's just a simple fact. So I hope this was helpful. I hope this adequately explained why the U.S. Supreme Court was hesitant to get into this case. I think they were right on the legal issue. The 9-0, there was no standing. I agree, there wasn't standing. I also think they're right on the doctrinal issue of being super hesitant to get into this because, there be dragons. They would put that right on the old school map. This is something where they got to be really, really careful. And I think they are being careful, and I think that's exactly what's going on. So, for those of you who are hoping that this would be decided, more substantively, to be in place for the 2020 census and the 2021 redistricting, which will occur because it's constitutionally required. I understand why you're hoping for that. I hope this helps explain why the court was hesitant. There are 4 members of the court who want to go there, so you're not out of luck. But this is one of those situations where the conservatives are being traditionally conservative. There's a reason the conservatives, put aside party, I'm talking conservative with a lowercase c. This is a reason that the conservatives are conservative, because they realize that this is a problem. I really don't think that this is because of Republican. This is because of conservative. There is obviously a difference, and you can think of some notable politicians of the Republican Party who might be not conservative without naming names. So there is definitely a distinction. And this is definitely an issue where the conservatives are being conservative, and I think for just reason. I hope I explained that adequately. I'll leave it off for now. For now, my friends, my name is Kurt Mueller. I am your favorite patent attorney. And we're covering partisan gerrymandering, Gill versus Whitford. Hope you're well, my friends. Till later. Bye.